Good morning, everyone. Thank you for joining us. My name is Jessica Trosclair. I'm the Return to Work Specialist here at Teachers Retirement System. I have Jeff George with me today, and we're going to be talking to you about the Return to Work laws. A little more in-depth than the webinar we did last month. We're going to look at the legislative changes, but also get a little more technical for you in terms of how you should be applying the law. We have a lot of information to cover, so if at any point you have a question, we do have a chat box where you can enter that question. Jeff may answer it if he's able to at that point in time. Otherwise, we'll try to address questions at the end of the webinar, especially if it's something that should be read aloud for the entire audience. If you have technical issues with the GoToWebinar platform, you can press F5 to refresh your dashboard. If you lose audio, you may be able to navigate to the audio option on your dashboard and kind of toggle between those two radio buttons to fix that functionality. So again, we have a lot to address today. Some of it will be an overview of things you've already heard or that you should be pretty familiar with. And then we're going to weave into that the changes that came out of this recent legislative session. If you were with us on our June webinar, you may recognize this slide. It is straight from that. We had probably 8 bills that were proposed this year that could have affected our return to work laws. 2 passed, one on the Senate side, one on the House. They are identical to each other. So 2 laws passed that made 3 sort of significant changes. We did have a few bills, specifically House Bill 22, that proposed changing the earnings limit. That did not pass. So that's still misinformation that I'm getting a lot of questions about from retirees. So just for clarification, the earnings limit bills did not pass. They will remain at 25%. What did change, and what we're going to look at in depth today, is the overall eligibility criteria for the individual laws. Within the 2010 law, there is a change to the advertisement process for critical shortage. And there are also 2 new provisions that could kind of be thought of as alternatives to critical shortage. And then we have a new law that is specific for higher ed critical shortage. It's a very specific scenario that we will look at today. Now, if you've sat through any webinar with me, and we've done a few over the years, you know I like to start with a really big picture overview of the laws. And so kind of give you the who, what, when of the collective group, so that then it makes a little more sense when we look at each piece individually. We now have 3 laws, 710, 710.1, and 710.2. These are the specific statutes that make up the return to work laws, and they're named by the legislative session or the year in which they were enacted. So 710 came out of the 2010 session. It is our 2010 law, or we may call it our old law. 710.1 was from the 2020 legislative session, so we call it the 2020 law. And then 710.2 was from this past summer, and so you can probably guess we call it the 2022 law. Now, these laws are only going to state what happens to a retiree's benefit when they are reemployed. They do not say whether or not an individual can or cannot be hired. They do not specify the positions that a person can or cannot be hired. They just simply say whether or not a person can receive their retirement check while also receiving pay from the employing agency. And of course, it doesn't apply to all employment scenarios with our retirees. It is specific to when a TRSL retiree is reemployed with a TRSL agency, and they're in a TRSL position, or they are paid to provide services that would otherwise be reportable to TRSL. I like to sort of provide that secondary definition, if you will, because the laws do apply to direct employment as well as employment by contract or corporate contract. So you may have an individual who is not technically your employee, or they may not be paid by your district or by your university, but they're providing services to your agency. And so in that scenario, the laws do still apply. This is going to be your staffing agencies, those working through a third party or a corporate contract type agency like your ACT prep or tutor companies, excuse me. It could also be anyone under an LLC or who you pay via 1099. Our auditing department, when they process your annual return to work salary file, they will be spot checking your 1099 vendor payments a little more than they have in the past. They will be looking a little deeper at those, even if there's no variance in the salary. So I want to make sure on the front end that we really have an understanding of when these laws should apply. Now, of course, we should also be familiar with the idea that disability retirees are not subject to these laws until they reach regular retirement eligibility. They are limited in their reemployment options, but it is a different statute that governs them. Additionally, ORP participants and LSU co-op retirees are not the retirees that are subject to these laws, and a retiree of any other state system, lasers or LSERS, they are not subject to these laws when working with your agency. So if we start looking at the eligibility criteria, this is going to be the eligibility, not necessarily for if the laws apply, but one step past that. So once you know that the law applies and you need to determine if the individual is in the 2010 group, the 2020 group, or if you're higher ed and they're possibly eligible for the new 2022 law. The eligibility criteria was changed this summer. It is now based solely on the retiree's date of retirement. So our magic number, our magic date, if you will, is still July 1, 2020. And we're just looking at whether or not retirees retired before July 2020, or if they retired on or after July 1, 2020. Previously, we looked at their reemployment history. And so there are some individuals who were reemployed under the old eligibility criteria, and they met the 2020 requirements. And now that the eligibility has changed, they are eligible for the 2010 law. There's only 700, maybe 800 of these in the state who are eligible for this, so it is a very small, closed group. But these individuals will be given the opportunity to convert from the 2020 law into the 2010. Individuals who by default qualify for the 2010 law still have the option of converting to 2020. It is irrevocable. So if someone has already made that decision, it remains. If someone makes the decision in the future, it is permanent. It is irrevocable. And so when we talk about applying this eligibility, when we talk about the placement of the laws, 2010 and 2020 are concurrent. They are both active. They're side by side, sort of sister laws, if you will. So an individual is initially placed into one of these laws based on their date of retirement, and it's an either or. They cannot be covered if they're employed with multiple agencies. They cannot be covered by both 710 and 710.1 at the same time. The 2022 law is optional, especially since it is such a specific scenario. It can overlap an individual's employment under one of the other statutes. So you may have someone who is under the 2010 law. There may be a substitute teacher with a K through 12 agency. And then they're also an adjunct that qualifies for the 2022 law. And they can be in those two, they can be covered by those two statutes at the same time. Being covered by the 2022 law does not prohibit a person from later being subject to 2010. And of course, if an individual chooses to convert from 2010 to 2020, that does not forfeit their opportunity to be covered by 2022. Okay. So we're going to go ahead and take a closer look at the individual laws. I don't have any questions yet about the eligibility, but if you have some, please let us know. There are, of course, two laws, and we're basing them, or two primary laws that we're going to place individuals in, again, based on their date of retirement. So we're going to look at our old law first. This is anyone who retired before July 1, 2020. It does include our grandfathered retirees. So these are people who retired before July 2010. They were covered by the old law, the law that was in existence before 710 was created. Of course, this will cover any individual who meets that sort of special transfer option, okay, those who can move from 2020 to 2010. There are a number of differences between the 2010 and the 2020 law, but one of the main differences is the waiting period. So we should be familiar with the idea that all retirees have a waiting period. The standard is 12 months, and it starts on their date of retirement. Now, this waiting period does not prohibit a person from being employed because, of course, the law does not tell you that you cannot hire someone. But it does say that an individual cannot receive their retirement check if employed during their waiting period in a TRSL position. The 2010 group has a 36-month waiting period in addition to the 12. It's only applicable for retirees who retired between July 1, 2017 and June 30th, 2020, so about a 3-year group. And it's basically for those who retired early. That's what that bullet is talking about when it talks about they were actually reduced or they have an accrual rate of less than 25%. This waiting period is mandatory. There are no exemptions, and so it supersedes any critical shortage or other provision that would allow a person to return without affecting their benefit. The other major difference from 2010 and 2020 is what determines the provisions and their applicability. So within our 2010 group, we're primarily looking at the position that the retiree is going to be employed in. So not necessarily what they were doing when they retired, but how are you hiring them? What position will they be in? What type of services will they be providing to your agency? And there are 3 potential impacts within this group. So the first impact is none. So they can be reemployed with no limitation, with no suspension. They may be employed in a capacity that subjects them to a 25% earnings limit, and that is 25% of their annual retirement benefit. And the third option is that they may be employed in a capacity that would suspend their benefit for the duration of reemployment. It is not a termination of their benefit. It is not a permanent suspension. They're just not receiving it while working. So if we look at this table, the first 2 provisions for subject and special leave, those are our 2 new provisions that came out of this 2022 legislative session. They allow someone to return without affecting their benefit. And we're going to look at those in depth since they are new. But you also have within the retired teacher category, the grandfathered group, the advanced speech degree group, and critical shortage, where an individual may meet criteria to be reemployed without affecting their benefit. No earnings limit, no suspensions. From there, there are 7 positions, 7 very specific positions that would give the individual an earnings limit. So that's your pre-K through 12 substitute teacher, tutor, proctor, presenter of professional development, adult ed literacy instructor, school nurse, and adjunct instructor for my higher ed agencies. If it's a TRSL position and they do not meet any of the above criteria, the position is different, or they are not grandfathered, they do not have an advanced speech degree, maybe they're a teacher but they're not certified, they fall into the retired member category. So this is a sort of catch-all group for anyone else in the 2010 law. And basically, their benefit is suspended for the duration of reemployment. Because individuals have the option to convert from 2010 to 2020, many people, once they realize that they're going to be considered a retired member, they may look at their other options because they could have an earnings limit or a different potential impact. So we'll look at that when we talk about 2020. But let's first take a closer look at these new provisions. Okay, I know one of the biggest issues right now is the teacher shortage, and you're all trying to figure out ways to fill those gaps and utilize retirees without affecting their benefit, without affecting the retirement system, and without too much impact on you as the employing agency. So critical shortage is still an option. You also have this new core subjects group. So it applies for individuals who are certified in math, English language arts, science, or special education, and it's applicable when a retiree is certified in that area and hired to teach in their area. Now, this does not exclude elementary teachers or substitutes. The retiree must be directly employed, and this particular provision is temporary in nature. And so that's twofold. The first is that it is only effective until July 1, 2027. So it does have a sunset date, or it sort of self-repeals in 5 years. But the other thing that makes it temporary is that it's not a guaranteed position. There is no declaration process with this core subjects category. So there's no advertisements or posting notice that you have to go through. But if you hire a retiree and then a non-retired person who is certified comes along and applies for the job that a retiree is in, then the law would expect you to hire the non-retired person by the start of the next grading period. Okay, so let me say that again. If you hire a retiree into their area of certification and you utilize core subjects, if an active member comes along and applies for that job, then you should sort of bump the retiree for the active member. They should be replaced. Now, again, I've said that the law does not say when you should or should not hire someone. So if you chose to retain the retiree, maybe the active member does not meet the specific qualifications of your district, or you know them and you know that they would not be a fit for that class or that school, whatever the scenario may be, you can absolutely keep the retiree or you can hire someone else. But if you keep the retiree, the core subjects provision would no longer be applicable. Okay, so you can choose to keep the retiree, but from that point going forward, their benefit could be suspended. I do get a lot of questions about the certifications, what is considered certified. A lot of these come from the retiree, but they really, I always direct them to the employing agency. So I'm telling them that they need to confirm their certification with you. I can only tell them what makes them eligible, what the criteria is. So we advise consulting the DOE Bulletin 746 for guidance on certification and what falls into these broad categories of math, ELA, science, and special ed. We have another new provision that allows you to hire someone without affecting their benefit, and it's the special leave category. This is only applicable for retirees who are certified at least age 62 and to have at least 30 years of service credit. And it's when they are directly employed to fill a teaching vacancy due to maternity leave, military leave, sabbatical, or extended sick leave. And those 4 circumstances must meet the definition or the criteria as outlined in Title 17, so their respective statute. Again, there is no declaration for this special leave category. The bump requirement, the active member replacing a retired person, that does not apply to special leave. Again, these are temporary in nature just by the fact that maternity leave and extended sick leave, et cetera, those are sort of short-term circumstances. They're not permanent vacancies. This provision also repeals on 7/1/2027. There is no form for these new categories. So the special leave and core subjects provision do not require any type of form. In fact, no enrollment under 2010 requires a form with the exception of critical shortage. And there you're just certifying that you've complied with the law. And we're actually going to take a look at those requirements next. What I do want to point out is that there are new certification statements included in the enrollment process. So in the online submission process, you will be asked to certify the certain criteria for the specific provision that you've selected. Each provision has their own option within this drop-down list. So I apologize, this menu is a little longer than it used to be. We have 8 new provisions. You may have to scroll down now to see the whole list, but every critical shortage option has its own, selection. Each core or special leave and earnings limit provision has its own selection. So moving into the critical shortage declaration process, this has been updated. It is a bit simpler once you fully understand what has changed, but I know that it's very confusing right now, especially because you're trying to quickly fill vacancies at the beginning of the school year. So I'm going to cover it here, but just know that we also have a step-by-step guide that tries to simplify the process for you, and it's available on our website in the Employer Procedure Manual. These new requirements are permanent. They do not repeal on July 1, 2027, the way the core subjects and special leave provisions will repeal. This is also new in that they apply to full-time and part-time positions. Part-time positions are not treated any differently than full-time now, and part-time is still only applicable for teaching positions. So when you're first declaring a critical shortage, you're now going to be declaring it for your parish or for your district as a whole. And again, this is critical shortage for a K-12 agency. You will be posting a generic statement that you are soliciting applications for the future employment of certified teachers. And that statement will be advertised at least once per month in your official journal, and then it must be continually posted each month in your official journal. It should also be posted at the Career Development Office of every higher ed institute within 120 miles, in-state and out of state, at the beginning of every semester. The third requirement that is kind of new for you is that you must display a list of all vacancies as well as all positions filled by a retiree on your website or the governing authority's website if a separate website is maintained. Okay, so a comprehensive list of every vacancy that you have and every position that is filled with a retiree, any type of retiree, even your grandfathered individuals, must be posted on your website. Once you have started the declaration process for your agency, and of course you're keeping up with it to remain compliant, then there are certain criteria that must be met to hire the specific individual retired person into that position. So first, the retiree must be certified in the subject area that you're wanting to hire them in, both full and part-time. Additionally, and this is not new, you have to have an applicant pool of fewer than 3 qualified certified candidates. Once you know that you have met that criteria and you're ready to move forward with hiring the retiree, you must still certify the shortage to BESI. You would certify the shortage to TRSL via the Form 15CS. And of course, you'll submit that online enrollment. The certification form has been revised, so it is a little cleaner. It's been simplified a bit because the advertisement dates are no longer required. We do still need the subject area or the grade level, as well as the dates of employment and the signatures of the superintendent and or personnel head. The critical shortage process is still an annual certification. And so what I mean by that is your advertisements are continuous. Month to month, you should be posting your notice in the official journal and also at the higher ed institutes, okay? But for the individual position, when you're talking about that specific math class or special ed teacher, once you hire them, they can remain in that position until the end of a school year, or shorter if you don't need them for that long. But on June 30th of the fiscal year, we will automatically terminate all critical shortage enrollments. And if you are wanting to utilize a retiree in the next school year, we would anticipate that you sort of go through the process again in terms of rehiring or opening up your application process, confirming that you have fewer than 3 candidates, and certifying and enrolling the hire to TRSL. All enrollments should be submitted within 30 days. That is standard for all provisions in in the return to work laws. And the critical shortage form that you're looking at here on your screen is expected within 45 days of the first day of hire. Now, when you submit the online enrollment, you're going to get a message that says the benefit has been suspended. Don't panic, okay? That is just a placeholder to ensure that you are compliant with the need to submit this form. Once this form is turned in to me or to someone else here at TRSL and it's validated, we will manually resume that benefit. So you have 45 days to submit this form. I typically advise that you do the enrollment and the form at the same time. One without the other could result in the benefit actually being suspended. We will, of course, pay them after the fact via a manual check, but they will miss their direct deposit. So I'm going to move into the 2020 law, but we did have a question about when contributions are required. And so that is something that I did not talk about today. It has not changed, but I will kind of briefly go over it. Unsheltered contributions are almost always required for retirees. There are 2 circumstances in which they are not needed. In the 2010 law, that's going to be your retired members. So if an individual is in the retired member or the suspension option with the 2010 law, they choose to stay in 2010 law and have that suspension, the enrollment is all that is needed from you. You do not report their salary. You do not withhold any contributions. Of course, a termination date would also be needed when the employment period ends. That is how we know to resume that regular monthly benefit. Within the 2020 law, which we're going to look at momentarily, There's one option where contributions are not required. That's when they're employed by contract. So let's go ahead and segue into 2020. This is what we call our new law, though it's been around for 2 years at this point, and we do have a newer law. You will still hear me refer to this as the new law, especially because 2022 is optional. And it's so specific, it is so nuanced that right now it's not going to be used as often as our other primary laws. So our new law 710.1 is specific to individuals who retired on or after July 1, 2020. It does include anyone who is eligible for the 2010 group and who makes the choice to convert to 2020. This group does require a Form 15 ELEC for every single enrollment that you submit under the 2020 law. So anytime you are enrolling someone and you pick a 2020 provision, or if you choose, you're prompted and you choose to enter Portal B, then you should also be submitting a form. The standard 12-month waiting period applies to the 2020 law. So if an individual chooses to convert from 2010 to 2020 and they had a 36-month waiting period in the 2010 group, then when they convert to 2020, the waiting period converts with them. Now, I said that there were quite a few differences between 2010 and 2020. The waiting period is one. The other difference is what we look at in terms of placing an individual into one of the 3 2020 provisions. Okay, so there's 2 potential impacts. One, a 25% earnings limit. Here it is based on the retiree's final average compensation, their FAC. That's a 3 or 5 year average of their highest consecutive years while they were actively employed. Okay, so 25% of their FAC, or the second impact potential is a suspended benefit that could possibly also allow them to earn additional service credit. Now, when we're deciding which impact applies in regards to the 2020 law, we are not looking at the position. We're only going to be looking at how the individual is hired. So there's basically 2 questions that you're going to ask once you know the 2020 law applies. One, are they a direct employee, or will they have to be, or are they considered employed by contract or corporate contract? If they are employed by contract or corporate contract, their only option is to have a suspended benefit. We have very casually and just for consistency labeled this as return to work option 3. That is not what the law calls it, but I like to give everything a label. So when they are employed by contract or corporate contract and you're enrolling them, you would select option 3, which is a suspended benefit with no contributions being required. If the individual is directly employed, then the second question is, are they full-time or part-time? If the individual is part-time, then their only option is the earnings limit, 25% of their final average comp. If they are full-time, they actually have a choice. So that's when these options are truly options. A full-time direct employee can choose between option 1, which is the 25% earnings limit, or option 2, which is a suspended benefit in order to regain active membership. So with option 2, unsheltered contributions are required, even though the benefit is suspended. And this allows the retired individual to receive service credit for their employment period. So when they're ready to sort of re-retire, they will have ultimately increased their overall retirement benefit. We will convert that service credit to a dollar amount that will be paid out to them on the first of the month with their original retirement calculation. And from there, that's it. So truly, 2020 is an incredibly simplified version of 2010. Similar impacts, less complex, in my opinion. You're not looking at as much. Any of your recent retirees are only going to have these three options. There is no critical shortage option. There is no core subjects. There is no special leave. There is no advanced degree carve out for individuals who retired on or after July 1, 2020. Okay. We have a couple of questions, so I'm going to quickly look at the 2022 law, and then I'll take a moment to answer a question or two before segueing into the more technical aspect. So if you thought the 2020 slide was short, 2022 is even quicker. Again, this is our new law for higher ed. It is a critical shortage piece that is specific to adjunct professors when they are employed in a nursing program where a critical shortage exists. Only certain retirees are eligible, so the retiree must have retired before July 1, 2020. They must have at least 30 years of service, and they must be at least age 62. In order to declare a critical shortage, higher ed agencies do have a similar ad process to K-12, but it is less exhaustive. It's not as extensive. You must list all of your unfilled positions and those positions filled by retirees in three places: the website of the post-secondary institution, the website of the institution's management board, and the website of the Board of Regents. And that is all of the 2022 law. Okay, so again, incredibly short, incredibly specific. So we have a couple of questions. After this, we're gonna shift gears and talk about how to actually apply the laws. So I'm gonna answer some questions real fast. 2022 does not have a form. It is similar to 2010 in that these certification statements are included in the enrollment process. Also, because this applies to only one hiring scenario, there is no drop-down menu. The return to work provision will be populated for you. It's just like our grandfathered retirees. So we have a couple of options talking about, I think, the 2020 law. And for anyone who thus far is confused or lost, if I've moved too quickly or you don't have an understanding of the laws at all yet, and this is too high level, please know that we do have more details about these laws, extensive details available on our website. The Employer Procedure Manual has 4 indexes that cover the statutes. Each individual statute has their own procedure manual. And of course, you can reach out to me at any point to go over specifics. But I wanted to keep today, since, you know, for the sake of time, I wanted to keep today kind of short. One of our questions is that if someone elects option 1 with an earnings limit and then they work full time, they're more than likely going to go over their limit. So what happens? So individuals who are full-time are eligible for, and I'm going to back the slide up so we can see it, they are eligible for option 1. Sometimes you can have an individual in a position that is not high paying, okay? So they may not actually exceed their limit. And so option 1 is beneficial for an individual in that circumstance. Other people will be full-time and they do not want to permanently suspend their benefits. So for that reason or other unknown reasons for us, they may choose to have the earnings limit. If an individual, whether full-time or part-time, exceeds their limit, it is a dollar for dollar overpayment. That applies to both the 2020 and the 2010 earnings limits. So when they exceed that earnings limit, however much they have gone over by is subtracted from their retirement check. So it could result in a one-time reduction. It could result, if they continue to work, in reductions occurring over multiple months, but with varying amounts based on their salary from you. It could result in a months-long suspension. Okay, they may go so far past their limit that they are then suspended for a long period of time. They could even be suspended beyond their point of employment. Now, individuals who are full-time can choose to move from option 1 to option 2 at any point in time. If they exceed their limit before changing, we do have to recoup that overpayment. And then, of course, the earnings limit will only apply to the salary that was earned prior to the switch. We have another question about whether or not a new 15 ELEC is needed. And so I'm going to read it aloud. It says, do we have to terminate retirees under the 2020 law for exception report purposes? And if so, is a new 15 ELEC needed? And so with the exception report, that is something that you should be clearing monthly. It is used as a sort of safety net. If you are terminating someone because they are not employed, then yes. When they do start working again, you should submit a new enrollment. Anytime you submit a new enrollment, a new 15 ELEC is needed. If the individual is part-time or their work is sort of random by nature because they're a day-by-day sub, you can choose to leave the individual employed because you know that there's the potential for them to come back any day. And if they don't have earnings for the month, post zeros for them. That is the other way to clear the exception that could populate on your report. Okay, so you do not have to terminate and re-enroll someone every 2 weeks or whatnot. Many times people want to be terminated over the summer so that they can receive their refund. But again, anytime you terminate them, you do have to re-enroll when they start working again. And if they're in 2020, you do have to submit a new form. You also have to submit a form if you are a second employer. So if they're already enrolled under the earnings limit with a different or a neighboring parish, and they're now going to be enrolled under the earnings limit with you, an enrollment and a form is needed. Okay. So we have quite a few other questions coming in. I'm gonna pause on the questions. Jeff is answering some of them as he can, but I'm gonna move on to the more technical aspects of the law. This may answer some questions. It may not, so feel free to keep asking them and we'll kind of hold a Q&A session at the end. But this will go a little bit quicker than what we've previously discussed. So once you know that the law should apply and you've been able to figure out which group they fall in, or maybe that's where you're stuck. You say, I know it's a TRSL position. I think I know which group they're in, but I'm not certain, or I have no idea how to figure that out. I know what the criteria is, but where do I find the information to even make this decision? Well, EMIS is probably the first place where you should start. Okay, EMIS is TRSL's Employer Member Information System. It is the online portal that employing agencies utilize to make any type of update to an individual's record. It's where you can view their salary or employment information. To first determine a person's group, you should be looking at their status on member summary. So that's the first screenshot that you see on this slide. So here, where you see the status, ILSBRET, that is a retirement status. You may also see a status that says that says drop ret, or it may just say retired. If it says ex-member, inactive, ORP drop member, those people are either not retired or they are not a retiree that is subject to the law, okay? So you're going to find the date associated with the retirement status. Now, under the ILSB status, you'll notice this screenshot says RTW337EL. Basically, if you see any status that says RTW and there's what feels like a random number or letter behind it, that is an internal status for TRSL purposes. That just lets you know that the retiree is currently enrolled or was previously enrolled in a return to work provision, and there are still contributions that have not yet been refunded. Okay, so you are not looking at any RTW status when we're talking about determining their retirement date, only the retired status. Okay, again, if that date is before July 1, 2020, they are in, by default, the 2010 group. If it is on or after July 1, 2020, they're in our 2020 group. Now, once you've determined an individual's retirement date, if it is before July 1, 2020, you'll next need to review their employment history. And this is just further down on member summary. But you'll need to do this to determine, one, have they already elected to move to the 2020 law? Okay, because of course that's an irrevocable decision, it is permanent. So even though they may have retired before July 2020, once they choose to convert, they're covered by the 2020 provisions. The other thing that is new that you're going to be looking at is whether or not they're one of these special individuals who were previously placed in the 2020 group, and now because of the eligibility changes, they're eligible for 710. They're eligible for our old law. And so the screenshots on the bottom of the screen show you kind of what you would be looking for. There is an exhaustive list of these different RTW types, these codes available in our procedures manual. Okay, so you do have to kind of understand these provision types or these RTW types. There are only 3 for the 2020 law, so that's a lot easier to remember to be able to identify if someone has 2020 history. The other information that's available on member summary or on the benefit payroll screen for you is going to be related to their earnings limit. So in sort of the middle of the screen on the member summary page, you'll see this screenshot to the left, their plan information. It may say regular plan, it might say, they might be a system 3 person, and so it would say plan B, but almost everyone should have an average comp or a before drop average comp posted if they have retired, okay? So that's a monthly average comp. You can also find it if you click on the individual's status. You should be able to access their benefit payroll screen, and you're limited in what you can see, but you should be able to find their final average compensation as well as their current benefit amount. And I've removed all other data from this screenshot so that it's highlighting what you're looking for, but this will help you determine what an individual's earnings limit is, which is especially helpful if someone is considering switching from 2010 to 2020. This is also helpful for you in that you can see if you've already enrolled someone. So if you have someone who wants to convert, or maybe you have an enrollment out there from last year and they're in a different provision and you're trying to enroll them, but for whatever reason it's not going through, or you want to confirm that the enrollment you just submitted was accepted, you can refresh the screen and check a person's employment history. We're going to take a quick look at the forms, the conversion forms for the 2010 and the 2020 laws. If someone chooses to convert from 2010 to 2020, and this is the conversion option that has been around for a couple of years now, there's been no changes to this. They do so via the form 15 ELEC. Okay, so section 3 is what an individual completes to convert. And then section 4 on the back is where they check off their option that they're going to be under. And then every enrollment from there on out still requires the 15, but they don't have to complete section 3 once they've done the initial conversion. Now, please keep in mind that the 15 ELEC does not make the conversion effective. Okay, it doesn't actually get reviewed by me at all. It is informational. It goes into the retiree's file. We do have to have it on hand if we need to review it. But what is actually needed from you, in addition to this form, is an online enrollment. Okay, so the way to think about this is that this form is the retiree certifying, yes, I am making this irrevocable decision. Yes, I know what the outcome is. I know how my benefit will be impacted. And then you as the employer are also acknowledging that change or that impact, and you will submit the online enrollment to make it effective. Okay, so you may have an individual who's already enrolled with you under a 2010 earnings limit, and they want to convert to 2020 so that they have a higher limit. You'll actually, even though the position has not changed, you'll need to go into the online system and change or update their enrollment. Okay. If you have one of those individuals who are eligible for the new conversion option, and I really hesitate to call it that because this is, again, very limited. It's only for a number of people across the state. But if someone is eligible to switch from 2020 to 2010, there is a new form, the 15TR, so like transfer. It's a similar form where the retiree is acknowledging what their decision means, that they understand the impact. Again, you will be expected to submit an online enrollment to make the conversion actually happen. So for us to actually apply a, maybe they're moving from full-time option 2 under the 2020 law to now core subjects or critical shortage under the 2010 law. Well, for me to resume their benefit, you will have to go in and make the enrollment change. Okay, and in that example, the retiree also has to submit the retirement application. So the 11 RTW, which is not pictured in these slides, but that 11 RTW is also required for people who were under option 2 and who are eligible and choosing to move to the 2010 law. Now, there are a couple of pros and cons about switching. Before this recent legislative session, it was a little easier for me to say that 2020 was advantageous, or the line was a little clearer. Now, not so much. The options and the eligibility under 2010 is a bit more complex. So the individual really needs to consider not just what is best for them right now in their current reemployment scenario, but also what types of employment opportunities do they think may come up down the road, especially if someone is teaching and it's not a critical shortage now, but it could be later, or they're subbing, but they know that there's the potential for critical shortage to come up later if they're coaching. And again, they want to leave themselves open for critical shortage. Sometimes it's easier to just stay 2010 and be under a retired member, because once they make that choice to move to 2020, they're forfeiting any future eligibility to be under critical shortage, core subjects, or special leave. Okay. All of that being said, 2020 is a great law for a lot of people. The earnings limit is available to all positions. It is not limited to the 7 like in 2010. Also, because it's based on the retiree's final average compensation, it is typically a higher limit than the 2010 earnings limit. For individuals who will have their benefits suspended, option 2 within the 2020 law allows those individuals to earn service credit. So they're still getting something for that employment period. The bonus of moving from, or the benefit of moving from 2020 to 2010 is, of course, having access to those provisions that allow a person to teach or to work in a critical shortage without affecting their benefit. Moving from 2020 to 2010 is binding until July 1, 2027, so it is temporarily irrevocable, for lack of a better word. So even though they may be core subjects now, the individual has to understand that if they are replaced by that active member, their benefit could then be suspended. Or if they move into a different position and they fall under retired member with 2010, that's just where they're gonna be until 2027. They cannot then choose to move back to 2020, okay? Not until the 5 years has elapsed. Okay, so with that, we've kind of covered everything, and I know I can sometimes speak quickly. Hopefully this was clear that we have an understanding, but I'm gonna take a minute and answer some questions. Jeff has answered a lot of them directly to the individual who has asked them, but a lot of them are beneficial for the entire audience to hear. So I'm just gonna read them aloud for everyone. And if you have a follow-up question, please go ahead and ask it at any point. So the first question is going back to our 2010 law, and it's, can you explain the provisions for a retired member? And so I want to clarify that retired member is a provision. Okay, so it is one of the provisions within the 2010 law. It is its own sort of category, and it's what I refer to as a catch-all group. So anyone who retired before July 1, 2020, and they are in a position that is not one of the 7 earnings limit positions, they are not in a critical shortage position, they're not grandfathered, they do not have an advanced speech degree, and they do not meet the criteria for the new special leave or core subjects. They fall under retired members. And now it seems like there's a lot of other options, and so it seems like retired member would be a small group. It's really not when you think about it. All positions within a K through 12 agency, for example, fall under TRSL, with the exceptions being those on the bus and your custodial positions. So when you consider your cafeteria workers, your support positions, your paras and your aides, when you look at people in the athletic department or people in administrative positions, these are all TRSL positions, and they would all fall under the retired member category. Okay, even teaching in a non-critical shortage outside of those core subjects or outside of a special leave scenario can be considered a retired member. Okay, this gets incredibly confusing for our retirees because they think about how they were employed when they worked. What did they do for a career? They think about if they were a retired teacher or a retired member for the length of their career, and that is not correct. So we want to educate them and make sure that we're educating you to understand that it's always based on the specific position that you are hiring them in that exact moment, at least for the 2010 group. Now, for those in the 2020 group who have met their 12-month waiting period, the question is, can they transfer to 2010 and be under critical shortage? This is a tricky question, okay? And so the answer is maybe. Only those 700 or 800 people in the state who are now eligible for 2010 by merit of having retired before July 20, only those individuals can choose to move from the 2020 law to the 2010 law to utilize critical shortage. If someone is placed in the 2020 group initially, so if they fall in the 2020 group because they retired on or after July 1, 2020, they do not have any option at any point in time to move to 2010. They will never have an option to be hired and it be called critical shortage as the law defines it. So that means you can hire them. You can have a critical shortage position. You may have done your advertisements and the only person that applied was a retiree that falls in the 2020 group. You can hire them, but they are not eligible to receive their benefit while working. They would be subject to the 25% earnings limit or a suspended benefit where they regain active membership. When we are talking about the critical shortage declaration process, and we talk about how individuals must be included in that comprehensive list of vacancies on your website, okay? This requirement is only for the critical shortage process. So I'm going to say that again. You have to include all vacancies and you have to include all positions filled with a retiree, but you're only required to post this listing if you are utilizing the critical shortage category. So if you're a larger agency that doesn't use critical shortage, or you're an agency who just chooses not to use critical shortage because it's too cumbersome, or for whatever reason you just prefer not to, you can absolutely utilize core subject and special leave without having to post the list of vacancies on your website, okay? The part of the law that says a non-retired person can bump or can replace a retiree, that is only applicable when the retiree is hired in the core subjects category. So if you have a grandfathered retiree and you've put them into a full-time teaching position and a non-retired person comes along, that grandfathered person does not have to be bumped because they're falling under the grandfathered provision. Same thing with critical shortage. If you're hiring the retiree and utilizing the critical shortage provision, they don't have to be bumped because an active member later comes along and applies for the job, okay? And when I say you're utilizing the provision, I mean, what type of enrollment are you selecting when you go into the TRSL system and electronically notify us that they're working? Which position type or which provision are you selecting and saying this is the portion of the law that is most applicable to the way this person is hired, to their certifications, or to their employment scenario? The grandfathered group and the advanced speech degree group, they can be employed in any position in any capacity without affecting their benefit. Okay, and those positions do not have the declaration process. They will not be bumped, but again, they should be included in that comprehensive list of vacancies and positions filled with retirees. We have a question asking about the retired member provision again, and I'm just going to read it aloud. And it says, what are the provisions for a retired member who is a former administrator if they desire to work for an educational consulting agency or provide professional development to the school district? So there are a couple of pieces within this question that I want to clarify for everyone. The author of this question may understand, but I want to clarify for the entire group. So when we say a retired member who's a former administrator, so just because someone was an administrator when they retired does not mean that they automatically have the retired member designation as far as the return to work laws are considered. Okay, so we don't even look at what they were doing when they retired. So if we were going to simplify this question, it would be, what are the options for someone who wants to work for an educational consulting agency or provide professional development to the school district? Okay, that's what we're looking at, is what type of work or what type of services will they be providing to your agency? And so from there, you have a couple of questions that you need to ask yourself or ask the retiree. One, when did they retire? If they're going to be placed in the 2010 group because they are a educational consultant, they may have a retired member. They may fall under the retired member category. So that would be a suspension. If they are a presenter of professional development, they could have a 25% earnings limit. If they choose to convert to the 2020 law, or if they fall into the 2020 law by merit of having retired after July, on or after July 1, 2020, then you need to determine how you're hiring them. Are they going to be directly employed, or are they truly contracted because they're going to receive a 1099, they're considered a vendor or a 1099 payee, or it's a circumstance where they're working with a third-party company. So under the 2020 law, those scenarios would suspend their benefit regardless of the type of work that they're doing. And I know that this gets really confusing for people when we're talking about these sort of third-party contracts. So I'm going to add on to this question and clarify this a little bit. When you have someone who is, so you have a staffing agency, okay, and you as an employing agency pays that staffing agency to help you work out the logistics of hiring substitutes. And then that staffing agency hires a retiree. So the staffing agency is who will actually pay the retiree. But the retiree is being paid to sub in one of your schools, so for a public school district. In that circumstance, we could kind of say the circle has been completed. We started with the school district, the money and the services move around, and ultimately we end up back at the school district. That's where the services are being provided. The return to work law applies. It is the same concept if you are utilizing a private consulting firm that does professional development, or an ACT prep company, a tutoring company, an accounting firm, an IT firm, private IT consulting. All of these things, if they were full-time positions, would report to TRSL if it was an active member, right? So that's kind of what you ask yourself. If I was hiring an active member to do this work full-time, would they be considered an employee, or would they fall under the membership of TRSL? Even if you don't have a need for a full-time person, or you don't have the budget for a full-time individual to do this work, if the position could be a full-time employee of your parish, the law applies regardless of how they're paid. If it's title money, if it's grant money, if it's federal COVID money, the law still applies. And so I hope that helps. I know that that is really a sticking point for a lot of people that ends up being caught on your return to work audit. It can make people fearful of using the return to work laws because, of course, you don't want to incur charges that are avoidable. It all starts with understanding on the front side when to apply the laws and also how. Okay, so we don't have any other questions. I'm going to take a minute and see if any others come through. I do want to remind you that we have a litany of resources available for you on our website. Sometimes it does take a little while for me to return a phone call or an email. It is a very busy time right now for all of us. So I do try to reach out to employers as quickly as I can, but just know that we do have all of the information, an exhaustive list of information available for you on our website, trsl.org. You can navigate to the Employers tab. We have our Employer Procedures Manual that has 4 different chapters related to the return to work laws. Each individual law has their own section. It will go into more detail. It has screenshots. It has step-by-step procedures for you. We also have a flow chart that is being revised. It should eventually be posted to the website when we can kind of navigate these more complex scenarios within the 2010 law. Of course, if you ever need anything, you are more than welcome to reach out to me. I have pretty good working relationships with most of you, and I appreciate all of your patience and the trust that you put in me. If you can't reach me by phone right now, I've been telling everyone, just send me an email. Even if it says, hey, call me when you can, know that I need a lot more information now to answer your question. So if you're gonna call or email and the question is just, can I hire Jane Doe? Or can so-and-so be a teacher? Or what is so-and-so's earnings limit? Unfortunately, those are not things that I can just outright answer anymore. And I wish I could, but I cannot. So you do have to do a little research on the front end, or at least gather a little more information amongst the different departments within your agency, how they're being paid, how they're being hired, when they worked, when they retired, etc. And then we can provide as much assistance as possible to you. We still don't have a whole lot of questions coming in, so I'm gonna go ahead and end things from here. You will be receiving an email sometime later this week with a recording of this webinar. It will also be posted in 2 separate spots on our website in the Employer tab, so you can access it there. And I genuinely want to thank all of you for coming here today and for sitting through this. Again, I know it's a lot of information, and this is a very busy point in the year for all of us. So thank you for taking time to educate yourself and ask questions and get to know these return to work laws. Take care.